and deny the motion, sir, and then you may now decide, did you wish to put on your own case?
Yes, ma'am.
Okay, and so are you intending to testify?
Yes, ma'am.
Okay, give me just a minute then. Okay, so do you remember that you have a constitutional right to remain silent during trial?
Yes, ma'am.
And do you understand that because the state has the burden of proof, the law does not require you to testify in order to win your case?
Yeah.
You understand that if you testify, you will be subject to cross-examination by the prosecutor?
Yes.
You understand that if you do not testify, the prosecutor cannot mention to the jury or suggest that failing to testify is an indication of guilt?
All right.
And so you've made your decision as to whether you'll testify, is that right?
Yeah, I think I can testify.
Okay. And since it is, let me ask, did you consult with an attorney, or did you reach this decision in a informed way?
Yeah, I guess.
Okay, well, you're the only one that'll know.
I mean, I don't know.
Okay, you don't know if you spoke with an attorney?
Well, I've spoken with lots of attorneys, and some of them suggest that you don't, some of them suggest that you do. Kind of depends on the situation, and
Okay.
I think there's certain things only I can bring in from my own testimonies. So that's why I think it would probably be beneficial for me to testify.
Okay. And you understand that your decision to testify or not testify, it's solely your decision alone?
Yeah.
Okay. And so it's your decision to testify today, and has anyone used any force or pressure to make you arrive at that decision? Is anyone
Who?
making you testify?
Yeah.
Who is making you testify?
The court.
Okay. And how did that happen?
Because I can't get certain things in without testifying, right?
No. Well, I don't know. I don't know what the case you're going to present is, so
Okay,
I haven't
yeah.
made you testify. I'm advising
Well, I
you.
mean, you haven't physically threatened me. I mean, just the court in general. Yeah, I mean, if basically, so yeah.
Okay.
Does that make
And-
sense? Sorry.
Okay. And so by virtue of simply putting you on trial, you believe that that's what you're referring to?
Well, and not allowing certain things in the court without me testifying I feel like basically I don't feel like I really have a choice, but I mean, I am making the choice. So if that's what you're saying, like nobody's threatened to blow me up or something or beat me up if I don't testify.
Okay. And so you made this decision freely and voluntarily because that's how you want to present the evidence that you have, and that's the way you think that you can present the case that you want?
That's one way to put it, yeah.
Okay. And so I'll find and conclude that you have made a knowing, intelligent, and voluntary decision to waive your Fifth Amendment right to remain silent. And so with that then, did you wish to make an opening statement when the jury comes in?
Yes, ma'am.
Okay, great. And so let's go ahead and have the jury come back. Okay, and I will admonish Garth, if there's another outburst of laughter, you will be removed.
What should I do if something's funny?
Then you should leave. If you're going to have that difficulty, perhaps now is the time. Deputy, would you please excuse that gentleman?
Wow. Jury's present in California.
Thank you. You may be seated. Okay, and so now, Mr. Jones, you wish to make your opening statement.
Yes, ma'am.
Please do, sir.
Yes, sir.
If you would like to come up to the lectern.
Like explaining this, my name is Robert Jones. I'm the one charged in this case. I think that the state has put on their case, and as you've seen, the entire...
Your Honor, at this point, I object to this argumentation.
And why don't you both come on up? Statement, sir?
Okay, so what I'm going to attempt to show you guys is that this was an event that lasted 8 to 12 minutes, complete, and the evidence will show that that no law enforcement showed up, that we left on our own, that we went there trying to be very careful not to step on property, not to break any laws. And we did our best to address our government official where we believed she was at. And I can't say that, can I? I'd like you guys to just understand that this is about 2 songs loud or long. 2 people playing, somebody playing 2 songs loud in your neighborhood. Is that a misdemeanor?
In your honor, if we may excuse the jury.
Okay, and so the jury may be excused.
All rise, please.
Okay, go ahead and have a seat. And Mr. Guerra-Batarte, you have a motion, I assume?
Your Honor, I think that the state at this point, from the statements of defense saying and trying to imply whether his conduct is a misdemeanor is against the law. The jury is instructed directly by the court not to consider punishment, clearly saying, is my conduct criminal? Exactly that. It's there to incite the passions of the jury, and once again to try to state that his conduct on that day was protected by the Constitution, which I believe the court had already admonished the defendant multiple times he was not allowed to do. I think at this point the state is well within its right to ask for a mistrial. Despite all of that, I am simply requesting that the court once again admonish Mr. Jones of the court's order. And I believe if it does persist, the state will then have a motion for your honor.
Did you wish to respond?
I don't understand what I said wrong. I know that we couldn't go into the punishment, right? But it is known that it's a misdemeanor, right? Is that what I said that was wrong?
Yes.
I can't say that it was a misdemeanor?
Can't say it was a misdemeanor, you can't say it was a felony, because those have penalties associated of a maximum type. And so it does imply that
I mean, isn't
aspect. So no, you can't.
Isn't
Do you
that
believe that you can make your opening statement without crossing that line?
How about I'm just done with the opening statement? I don't know. I don't want to go through this whole crap again. Or, excuse me, sorry. I don't want to go through this again. So as far as my opening statement, I'm willing to just leave it where it stands and move on to witnesses, I guess.
Okay. Now, with your testimony, I assume you're going to be attempting to testify in the narrative. Is that correct?
What do you mean by that?
Well, there's no one here to ask you questions. So,
Yeah, which is weird, huh?
So will you be simply giving a recitation of whatever it is that you wanted to say?
To a point, kind of, huh?
Are you just going to be talking, or are you going to ask yourself questions and answer them?
Kind of the second. I want to answer a few questions I would have seeing this. Is that okay? Like if I was a juror answering the questions, would that be okay or no?
So until I hear your questions, that's going to be hard for me to answer. But
Okay.
I would advise you that, again, don't talk about misdemeanors, don't talk about felonies. And if you do want to testify from your own personal knowledge of what it is that you perceived on that day, you may testify to that.
Okay.
Okay?
Okay.
And so, again, what you testify about is your personal knowledge.
Okay. And something, just so that we don't come into this again, this doesn't qualify for a noise ordinance violation. Does that mean I can't say that because?
You cannot discuss that, okay?
Okay.
Okay, so the jury decides what the facts are, the state decided what they're going to charge, and trying to discuss various other ordinances and so forth is improper. So let's
Okay.
make sure you strike that off, whatever your
Okay.
your notes are. Okay, let's go ahead and have
And
those folks.
Your
come
Honor,
in.
I apologize before Mr. Marshall grabs the jury.
Yes.
It is the state's request. I understand Mr. Jones is done with his opening, that Your Honor simply read to the jury that they are not to, that little phrase, they're not to consider the punishment nor sympathy, if Your Honor is so inclined.
And rather than draw additional attention to it, it is in the instructions. And so I believe that will be satisfactory.
Thank you, Your Honor.
Go ahead.